As an elder law attorney, I am frequently asked to help protect the client's home. The client's home is their most valuable asset. For the typical client, the home equity is a large percentage of their net worth. What the client wants to do is remain in their home, age in place, and then leave it to their children. However, there's significant risk to doing that. And one of the significant risks is long-term care expenses. The in-home care assistance that they may need in their home is $16 to $20 an hour. If they have to leave to go to assisted living facility, $35,000 to $50,000 a year. Care in a nursing home, $75,000 to $85,000. The cost of this care would quickly consume whatever equity that they had in their house. In addition to that, living in the home requires maintenance, paying taxes, keeping it insured. Who's going to do that in the event the client suffers a period of incapacity, for example, due to dementia? All of those risks exist. So in helping the clients, they'll come to me and they'll ask me, what are the alternatives? One of the alternatives that will frequently be mentioned is, let's give the house away to the children, but there are risks there. What happens if your child dies or becomes incapacitated? Suddenly your daughter-in-law, son-in-law owns the home. What happens if your child has a financial problem? Suddenly their creditors will be seizing your home and you've lost control. So we don't recommend that. We frequently recommend an irrevocable trust. What is an irrevocable trust? It is an agreement between the client which transfers their home to a trustee, and the trustee agrees to manage that house pursuant to the terms of the trust agreement for the benefit of the beneficiaries. The client will look at me and say, but Andy, I've given up control again. And the answer is no, because under the terms of the trust agreement, they can retain significant control over the house. What are those controls? One is they can change the trustee. They can fire the trustee and replace the trustee. Frequently, the trustee is going to be one of their children, and they'll trust their child. However, on occasion, there may be a disagreement, and merely the child knowing that the trustee can be changed and transferred to someone else, it means the child is going to be carefully listening to what you want done. In addition to that, the trust agreement will provide that the client has the right to reside in the home as long as they choose to do so. If the house is going to be sold, the sale must be approved by the client. And if the client wants to approve the sale of the home, it could approve the purchase of another home, a replacement home. In addition to that, the client retains the right to direct where the assets are going to go at the client's death. Therefore, the children are going to understand that if they are not listening to the client, visiting the client could disinherit them. All of those significant controls means the client hasn't given up control over the client's home. But what are the benefits that are to be derived? Well, yes, for 5 years after we fund the trust, there will be a penalty imposed if Medicaid is applied for. And the reason I mention Medicaid, because that is the source of help that most clients, most people turn to when they need long-term care expenses. But after that 5-year period, there will be no penalty. The house will not be considered a resource for determining eligibility for Medicaid. In addition to that, the income tax benefits of being able to sell the house, exclude $250,000 of gain, real estate tax relief are all retained. Additionally, your children will get a step up in basis at your death, so that means they could sell the house after your death without paying an income tax benefits. As you can see, with effective prior planning, the client really can have their cake and eat it too, meaning get the long-term care assistance they need while retaining control over their home.